audible, Phaneendar sir?
You're audible, sir.
Okay, yes. Once again, good afternoon to all the participants and the resource person, Phaneendar sir. I welcome all the participants and the expert in today's second day of the workshop on the forensic science. And today we are going to have the session on the digital evidence and the legalities of the digital evidence. So I would directly like to request Phaneendar sir to start with the session. Over to you, sir. Thank you.
Thank you. Yes, I welcome you all for the discussion on the digital evidences. Yesterday, we spent some time in understanding the documentary evidences. Today, this discussion is specifically for the electronic evidences, which is also nothing but the digital evidences. So before we start with the actual topic, just like yesterday, we need to also now discuss about the question as to what makes an expert in this particular segment. Because yesterday हम जो discuss किए थे, that is exclusively for the fingerprint and document experts, or those subjects which doesn't have any kind of academic degree or full-time courses available, which is also considered to be a foreign skill or a foreign science. But today's discussion, it is not a foreign topic at all, because we have been using mobile, we have been using computers, and there are a good number of university courses. Since the time the Information Technology Act has been enacted, or since the time there has been an amendment in the Indian Evidence Act related to the digital evidences. So there are a good number of universities, there are a good number of institutions which offers full-time courses related to the computer and electronic devices. So for this reason, today's discussion, to understand who is an expert in this particular stream, there are a few important provisions of CRPC, Information Technology Act and Indian Evidence Act. Let us first make a note of these two important provisions. First, the understanding about the electronic examiner of electronic evidences, EEE. There is a provision for this EEE, Examiner of Electronic Evidences, under section 79A of Information Technology Act 2000. Please make note, because this is one section which provides a good understanding as to who is this EEE. EEE in sense, Examiner of Electronic Evidences, as per the Information Technology Act 2000. According to this section, it says, state or central government, upon a gazette notification or official notification, can nominate a person to be the examiner of electronic evidence as per the section is applied. The question and understanding is that since 2000, the same provision is there, but we are in the year 2022, and for all the possible and practical reasons, till the year 2018, there was no such official notification done by any central government agency to nominate and designate someone who should be called as EEE, Examiner of Electronic Evidences. There was no notification at all. Only in 2018, in pan-India, across India, there were 7 agencies who were actually considered to be EEE as per section 79A. My question to all the participants is that, what was happening for all the reports, all the examination of evidences since 2000 and 2018? How were these evidences being examined while there was no expert under the section 79A? And how were the evidences being examined in absence of 79A? Can someone comment about this? Participants, can somebody comment about this to make me understand, according to you, what is that provision of the law in absence of a person under section 79A, what allowed the person to be an expert? You know, law students, we only believe what is mentioned in the law is what applies. Whatever is not mentioned in the law doesn't arise. That is the principle what we usually adopt. But law is so vast and so specific, so defined, that whatever should be the ultimate understanding, those are clearly defined in our sections. So as per this section, when there is an absence of such notification, so question arises, are here almost 20 years. How did the FSLs, how did the investigations go on? Isn't it? So the answer to this is again some discussion which we discussed yesterday. That is section 45 of again Indian Evidence Act. In absence of such notification under section 79A, the people or the experts who worked so far in this past 20 years, or almost 18 years, they were actually taking the provision of section 45, which applies for any expert who possesses a foreign science or a foreign skill in a foreign science or a foreign art. So because of the reason there was no notification, this could have been the provision taken by any experts. But even today, only 7 such agencies in India are notified under this provision. And even if you consider there are, assuming at least 30 FSLs across the countries, I'm talking about SFSLs, every state need to have one, even if you consider that. At least 30 FSLs must be there. And every FSLs might be examining the electronic evidence. कोई भी डेटा ऐसा हो कि मोबाइल में है, कोई भी डेटा ऐसा हो कि कंप्यूटर में है, CCTV footage होगा. So if you consider these things are the evidences, so there must be some kind of examination need to be done. There must be some kind of authentication which must be done for these evidences. So even today, how is this examination being done? When this is the question, the only answer is that yes, section 45 is the answer for that. But you must also note one more provision, 45A, section 45A of Indian Evidence Act. Because in this section, it talks about relevancy of the opinion of experts. 45 talks about the opinion of experts who is handwriting and fingerprints or any such expert who possesses a foreign skill or a foreign art. But 45A specifies the relevancy of experts' opinion as taken under the provision of section 79A. Which means a person who has given the report under the provisions of 79A, who is notified as an expert, his opinion is relevant under section 45A. 45A and 79A are both linked. Okay? But for all the other practical reasons where the 79A doesn't apply, there are many FSLs across India, CFSLs across India, who does not have taken or who have not been given the recognition as electronic examiner of electronic evidence, they still come under the provisions of section 45 of Indian Evidence Act for the understanding of the experts. Is there any clarification about this topic, what we discussed, before I proceed with the further understanding about the computer and electronic data? Anybody has any question about the electronic evidence? Experts. I see. There is no questions on this. Okay. I'm just trying to share my PPT so that. Sir, am I given the provision to share the PPT?
Yes, sir. You can share your screen.
All right. So my screen is visible?
Yes, sir, it's visible.
See, when we discuss about the electronic evidence, there are two scenarios. One, this category of evidences comes under the cybercrime. That is one possibility. Second possibility is that even if it is not a cybercrime, but the data which is available as an evidence in a particular case, it could be any other criminal case or a civil case, it could also be some family matters or any kind of business transactional issues. For all these things, there are a good number of communications which we do using our digital devices. When I say digital devices, anything which works on electronic medium, be your earlier days, we used to have this digital diaries. People used to have a Casio company का एक छोटा सा डायरी जैसा लग रहा था, ओपन करके just like कंप्यूटर का कीबोर्ड जैसा रहता है. We used to type the data in that. That is called PDA, personal digital assistants. So this, including this PDAs, mobile device, our computer device, the networking device, so all these things comes under the digital understanding of the evidences. Any data which is there on this platform, which is to be used as evidence, definitely is a digital evidence. So when we on the screen, when we look at specifically for the purpose of cybercrime, in cybercrime there are only two possibilities. One, the computer is a target. Any computer, or when I say computer here, it is an electronic device. Okay? The computer is a target, or using computer, the crime has been committed. In only these two possibilities, the cybercrime would be understood. But electronic evidences are of different natures. So just to give you a quick understanding about the cybercrimes where the data is always in electronic form, you are able to understand. There are two understandings. One is the data which is in digital format, which is required for any other case, IPC, your family matters, business transactions, that is on one segment. In the case of cybercrimes, there is always a digital evidence. In other kind of cases, there may be evidence in digital nature. Okay? But just to give you a quick understanding about nature of cybercrimes, crimes are against the person, crimes are against the properties, or crimes against the government or the nation. That is the simple understanding. But to go ahead, on the screen, we can quickly take a screenshot of this where we can save time in discussing about this. These are the few types of online or the cybercrimes in which the data or the evidence is always in electronic format. When we discuss about the digital evidences, these are few platforms where you get the digital evidences, which includes the hard disks. Hard disks may be present in computer, laptop, even the CCTVs, the DVRs or NVRs, what we discussed today, will have a hard disk. So that is one data. Next is the pen drive, flash drives, the memory cards, all these things comes into one more. And the third one you can see is the flash drives. Okay, the dongles. I'm talking about the security dongles. Next is the mobiles and the discs, the CD, DVD. These discs are not in very regular practice, but still we are in that phase of transformation where we are now in the mid of transforming the technology between the CD to the cloud or to the pen drives. So earlier we used to have the CD and DVDs. So we are in the transition phase. So for the today, the CD or DVD can also be the electronic evidence for our discussion. Yes. So the question for the examination purpose is that, or the question about the investigation aspects is that, There are a few essentials for the purpose of investigation. However, when you are cross-examining an expert who has given the report on the basis of electronic evidence, these things becomes your topic of discussion as to what is the hardware configuration the expert has in his laboratory, what are the tools, what he has used for the examination of the mobile phone, for the examination of computer, pen drive. You must know that the digital forensic platform is so wide that single application does not help you in examination of all the evidences. Suppose I have an Android phone. To examine Android phone, I get one dedicated software. And that software might not be as competent to examine the iPhone. So for iPhone, I need a separate application. So this is about the mobile. And for examination of the mobile phone, without the screen lock being opened, I might be using a different software. Okay, with password, without password, I might be using a different software. And next, the memory card. Memory card, recovery of the data from the memory card, pen drive are all probably a different software. So examination of the network devices like switches, routers, or cloud examination, the application is different. So like that, every device in the electronic medium might have different softwares. And what we have to understand here is that licensed softwares is very, very important, because we are not supposed to be examining on the basis of any open source tools. See, suppose if I ask you a question, how many of you have tried recovering the deleted data from your mobile phone from any application available in the internet? There will be a lot of people in this. Suppose I lose the data from the pen drive. First thing you do is go on the Google, search the tool to recover the deleted data. Whatever tool you get, you only require the data to be recovered. So you are accessing an open source tool for your purpose. But for the purpose of forensic examination and forensic reporting, we often don't use the open source tools. For every such platform, we require to have a dedicated licensed softwares. So your question to any expert would be, what are those tools which you have used? Is it licensed in your name? Okay, so these things, because if he doesn't own a licensed software in his name, how did he do the examination? Or did he report in his report that he has not used a licensed software, or has he taken help of some other laboratory which owns this software? So these things becomes a question for lowering the integrity of the expert, the credibility of the expert. So this is a basic requirement for the examination of electronic evidences. So I'll quickly go to the topic of our discussion, that is the electronic data. In today's legal practice, or in today's litigational practices, basically the category of evidences what we see is in multimedia format. When I say multimedia, images are the evidences, audio is the evidence, video is the evidence. Okay, so these three are the basic category of multimedia evidence. In any case, this is one such category which is used as a, because apart from this, there could be question about WhatsApp data, there could be question about email. So those things are different. I'll also discuss about that. But right now, what is very predominantly observed category of evidence before the litigation is a multimedia forensics. So in multimedia, we have this discussions where audio, video, and images are the basic category of multimedia evidences. However, where do we get this multimedia evidences these days? We often get this from our mobile device. So mobile device will contain all this category of evidence. In addition to this, you might also have emails in the mobile phone. You might also have the WhatsApp in our mobile phone, SMS in our mobile phone. A lot of data today is available only on the mobile phone. Police these days are able to crack good number of cases only on the basis of the mobile phone as evidence, because Mobile phone will contain all your, there are cases where your call records are there. You must know that the service operator, Vodafone, Airtel, BSNL, they will not record your audio conversations. They will not have any recording of anyone who is using the network. It's only when police request that this number is to be tapped, then there might be a recording available to the police officer. Okay? But otherwise, no operator will record your phone conversations. But the mobile phones what we use these days might actually contain the applications to do auto recording, call recordings. So in the mobile phone, you get to also listen what did these people speak. But the network call records, the CDR, what we usually call it as, call detailed records, CDR, which the police will take in every investigation case. This will only confirm there was a call from X number to Y number at this particular date, and they spoke for this particular timeline, and they would have spoken at the nearest tower which was giving the signal. Even the tower location could be given, but what did they speak? The operator cannot be giving you the confirmation. So this information is only available on your mobile phone, depending upon your settings of the mobile phone. That is a subjective question. Apart from that, SMS, for every transaction of the banking, you will be getting a transactional SMS. That is one good evidence, because if you have taken money, if you have given money to someone, the transactional SMS will be always there in your mobile device. It is not again available by the service operator. Only in rare cases, police or special investigation teams have requested and those have been procured. But in regular cases, this is not usually available, but such data is available on your mobile device. Next, you don't know, I would ask everyone to just access your mobile phone and go to your, the basic options like this. And do you see the location option on your mobile phone? Just check what you people have done. The location is always on our smartphones these days, because any application which you want to use it is tracking your location. Suppose you go out to your friend's place, you want to order something on Swiggy or on the Domino's, it is taking your present location to deliver that food. If your location is not there, they cannot deliver your food. So the location-based tracking system is actually there in most of the applications what we use these days. So by default, our location is always kept on. And when we keep our location on, whether any application uses your location or not, but the Google is always using your network, your location. Isliye, when you go to some famous restaurant, the moment you come out of that, there will be a notification. Do you rate this particular, restaurant? Had you been here? So help us in filling out some information, karke, because the Google is tracking your network, and this is a very good evidence when it comes to the police investigation cases. Where were you at this time? What were you doing there at this time? And Google is also tracking how did you go there? Did you take a bus? Did you go by train? Did you go by metro? Did you take a two-wheeler, four-wheeler? Everything, the Google will track it. And you should not be surprised that on your email, you will be getting a timeline of the events of the Google. Every month, the Google will send you the timelines. You can also check, your history, location history, to understand where and all you were, what and all you did. So this one, for this reason, the data on the mobile becomes very, very important for the investigation purpose. So apart from this, social media chats, emails, and SMS, MMS, all these things is generally available on your mobile device. So for this reason, mobile forensic is one good approach for the investigation purpose. So in the process of the examination, this is the technical information. When you want to understand how the mobile forensic examination is done, okay, this is how in different stages or different phases we do the examination. And first important thing, when the police is recovering or seizing an electronic device, the device must not be switched on, or it should not be connected to any active network except and otherwise by the investigator, matlab the forensic investigator. Suppose I seize this phone from an accused, and I must keep this phone in aeroplane mode only. And if I keep the data only in aeroplane mode, I can secure the data on my mobile phone. It's true that if you change your WhatsApp, for example, you change your mobile phone, you want to change your WhatsApp number to first device to second device. The moment you switch on the mobile phone and activate your WhatsApp, you get OTP on the new device. When you press OTP, the data which is on the WhatsApp, the entire data comes onto the new device. The backup and the current data, everything comes onto the new device. And the data on the old device is lost because the WhatsApp is not active over there. If such thing is done by a criminal, matlab, when the police seized the mobile phone, there was good evidences on the WhatsApp. And if the police did not put the phone in the network, matlab the aeroplane mode, by the time police got the mobile to their station, the accused can parallelly activate the WhatsApp, delete everything on the WhatsApp, and on the seized device, you get nothing as a data. So to preserve this data, it's essential that the phone has to be kept in network, matlab the aeroplane mode, so that there is no interface. When it is kept in aeroplane mode, the data is secured until we do the examination. So this is the purpose of the mobile or any kind of computer device to be not to be accessed by the investigator, but it must only be accessed by the forensic examiner. I'll give a small scenario. Suppose police goes and seized a particular laptop in which there was a suspected anti-national activity, or assume there could be some kind of child pornography content. Police got this laptop after seizing. Seizing, there should be a report, right? There will be a seizure report witnessed by two people, seized time, assume 1 o'clock on 31st of March 2022. This is a seizure time. So this laptop was taken to the station. By 5 o'clock, 6 o'clock in the evening, inspector wants to know what is there in the computer. What he does, he opens the computer, finds all the evidences in that. Oh, I could see this file having this content, it's good. But what happens in the examination is that when we do the examination, we also report the last accessed date and time of the particular device. In the computer examination right now, I'm going to say this computer was last accessed at 6 o'clock on 31st of March 2022. But the seizure time is 1 o'clock in the afternoon. The last access date and time is 6 o'clock. And because of this reason, the question might arise, if the data can be implanted later on. When they seized the device, there was no data. And by evening, they put the data to frame a particular person to the particular offense. This is a good defense, isn't it? So for this reason, there is something which is very important to be understood as a hash. Please make a note, the terminology HASH, hash. This hash value has also been discussed in the Information Technology Act as well. Hash value has also been discussed in the Information Technology Act. What is hash? Hash is a file integrity value. And this is very important to be noted, dear participants, because all the computer evidences will have this hash. Hash is the file integrity value. After this session, I'm going to share a link in which I'll help you to understand, to download a hash calculator, which is an open source tool available. You can do it as an experiment from your side. you can download on the internet hash calculator. There are good number of tools available. In that hash calculator tool, just load any of the file on your computer. It could be a simple Word document. Just load that Word document on the hash tool and calculate the hash value. You might get a big alphanumeric number, 16 digits, 32 digits, something like that. You get that hash value. And that value is because of the file which you calculated. Suppose if I have an image, and for the image I calculate a hash value, that will have a particular value, just like a random alphanumeric number. So when I have used this particular image for the purpose of examination, and when I have certified that this was an image which I have examined, I must also report what was the hash value of the image which I have examined. Okay? Because hash indicates the value integrity of the file. I'll make it very simple. Suppose in the Word document, you create a Word document with the content, I love India. Save it and do a hash calculation for this particular Word document. You might get one particular value. Save it. After this, just add I love India ke baad one extra dot. In the previous document, there was no dot, full stop. There was no full stop. But now you just put one full stop for the purpose of the hash calculation. And just because you have added one extra dot, the hash value does not be same. Okay, so what I'll do right now, I'll just, Pratik sir, I'm actually asking one of my staff to join.
Okay.
Okay, and please allow that person to give the screen sharing option for that.
For all the participants?
No. One participant is going to join right now. My staff member will show the hash calculation on the screen right now.
No problem. No problem. Let him join.
Yes. Participants, while I'll be demonstrating how the hash is to be looked at, this hash value is a very, very important piece of information for any kind of digital data to be examined. On the screen, I am now going to show you how the hash value, using the hash value, how the video authentication reports are prepared from our side. When we have one evidence of a video file, what all the information helps us in authenticating that? When this is the question, I'm going to show on the screen right now on how the simple video or audio file or any digital file. Yes. Yes. On the screen, you can see a particular format of the video. So this video is an evidence in this case. We might have to authenticate this video for basic reasons, which includes, is this video being edited? There can be a possibility where I take my video, I'm capturing some information, and I pause the video because I'm done with my requirement. And suddenly again, there could be something else happening. So I capture it. So like this, the present video which I'm using it as an evidence, is it the result of multiple videos being clubbed and made as one video? Or second thing, I recorded a video of 1 hour in which I have also abused you, you have also abused me. Just for the purpose of the case, I don't want to say, I don't want to give the evidence that I have abused you. What I'll do, I'll just cut off whatever the information I don't require. And I only keep the data which is in favor of me and make that as one video. submitted as an evidence. So in such cases, video authentication is to be done, whether if video is trimmed, edited, or there is any morphing which is done. So this is the primary question for electronic, especially multimedia evidences. So when this is a one simple video file, now look at the hash value, SHA256. So you don't have to worry about SHA256 because this is one set of algorithm which is giving me the value. However, there should be a hash value. Hash values are of different generations. Earlier, we used to use something called as SHA1. Now we are using SHA256. If people who are interested to know what is this SHA256, Google it, you'll be able to find it. Otherwise, it's a technical information. As a legal professional, it's fine, even if you don't worry that so much. But what is important? Hash value must be there. Okay, so now this is the video. And while we're doing the examination, look at what all things are authenticated in the particular given video. It's all the technical information. How do we capture it? What is the bit rate? What is the format in which the video is being recorded? Okay, what is the hardware setting? Suppose every phone has its own hardware settings. So what are these settings for this particular video? Everything is reported. And this also goes with the time stamping, time and date stamping. We can ascertain when was this data captured. If it is not a edited sample, if it is the original sample, then we can actually ascertain when was this captured. In this, because this is a morphed or edited video, we are not able to say when was this captured. However, I'll show you one more report how the date and time capturing could be shown in the whole thing. So can you please confirm if the Sarmati is here? Sarmati is in the meeting. Okay, she's not joining. Okay. Yes. Are you able to see my present screen, dear participants?
Yes, sir. Yes.
Yes. Here we can observe this is the case of email authentication. See, in any kind of electronic authentication of the evidences, it's very important that the examiner reports on date and time of such file being created. See, the file creation date is not the date on which this file came on to your device. That might also have a different date significance. But what is important for us is that when was this file actually created, not when it came on to your device. These two dates might be different. But what is important in the investigation is that the date on which the file was initially created. So that is generally possible in the forensic authentication of the evidences, be it via email, be it via WhatsApp, be it via any kind of image, audio, video. So those things are generally possible in our examination. But what you must understand with the electronic data, when the question is about, oh, one moment. Samati? Yes. 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 Sir, my staff is joining now. Please.
I've admitted that.
Yes. Sarmati will now share her screen to demonstrate the hash calculation. But meanwhile, when she's setting it up, what is important as an advocate to question and understand about the electronic evidences is that in audio and video, in both the cases, the question arises if the entire audio or the entire video is the result of single capture or multiple capture and tailored. I can see if there are people who do this recordings, singing karte hain, usko remix karte hain. So they can sing bit by bit, and then they can make it as one particular audio or one particular video. So if this evidence file which we are examining, which we are holding it, is this the result of such editing and joining, becomes a question. If such editing and joining is being seen, that is not a legitimate evidence, is what the understanding is. And for this, you must specifically understand the provision of section 65B of Indian Evidence Act. Please make a note. 65B of Indian Evidence Act. Elaborately, this section provides how the electronic evidences can be considered for the purpose of examination and the evidence requirement ke liye. Participants on the screen, we are seeing a tool for the hash calculation. I just mentioned before this, there are different kinds of algorithms which could give you the hash value. For this time being, we will choose SHA-256, SHA-1 and MD5. Let it be on, Sarmati. Please load any file for calculation. Participants, assume we have an evidence file in a Word document. This audio itself is a evidence in our case. So for the purpose of examination, this audio is loaded to the hash calculator. It's just dragged and dropped. Okay. Minimize the screen. Yes, hold on, Sarmati. Participants, now look at the screen. For the same file, the hash value under the algorithm MD5 is different, SHA1 is different, SHA256 is different. But Sarmati, can you please take off MD5 and SHA1? Fine. What we will do, we will report this file has a hash value of under SHA256. This is a hash value, and this is a file which I have examined. I'm going to report in my report. I'm also giving a copy of the examined file along with my report. Any other person who wants to conduct an examination on the same device will first verify if he has got the same hash value for his examination. Any file having the same hash value, for example, if I have used this audio file and got SHA256, this length of hash value, and if you are another examiner who want to verify if I have verified this audio file only or not, if you have to load this audio file to again hash calculator and you choose SHA256, you must also get the same hash value. It's only then you could understand the file which I have examined and which you are trying to analyze, both are same. In electronic evidences, this is possible. If I have examined one particular file, I should report on the hash value, and you can also verify if I have examined the same file or not by calculating the hash value from your side. So the file integrity is always verified by the hash value. And when the hash value is verified, only then you'll be able to confirm, yes, this is the actual file which they seized, which they examined, and the same copy is also made available before the court. So this is the understanding about the electronic evidences. It could be any category of electronic file. The hash value would always be calculated. It be a Word document, image, audio, video, email, anything, screenshots. Every file can be having a hash value. Hence, hash value is the file integrity value of any electronic file. Participants, any question about the hash value? Okay. Sarvati, can you quickly load an audio sample to the authentication software to understand if there is any manipulations between the audios? Recently, you had one case. Participants are probably now I will be demonstrating in one case where the audio was trimmed. Matlab, the audio has been spoken for 1 hour, for example, and they have only tried giving the audio file with a favorable content. They have taken off some content in that, and they have just tried to give whatever suits their requirement. So when that audio sample was examined under the forensic tools, this is how it looks. Spectrograph, hold on. Participants, you can see there is an abrupt change or abrupt gap between the audio. You can see the graph wherever they have spoken. You can see the graph, and there's an abrupt straight line. While listening, you will not have any kind of gap in the listening. You get to see continuous words being spoken. In the forensic tools, wherever we are able to see the gap, that indicates that there is some kind of manipulation which has happened. Sarvati, can you show the spectrographic view? You can see wherever you can see the black color gap, that is the space where there is something which is taken off. There's something which is fishy in this particular length of black and black mark. Hence, this audio file cannot be considered as an evidence because the audio file is now examined, and in the examination process, we could see there is some manipulation. For this reason, this audio is not the source audio. When I say source audio, you must give the entire recording if you want to claim that recording to be an evidence. So this is the significance of audio. Same or similar approach is also taken for video footages, video clippings. Same thing is done, and if there is any kind of manipulation which has happened, such kind of tools will show us that there is the manipulation at this kind of place. Okay, fine. Sarvati, thank you. You can close your screen. All right. Participants, now my question to you is that, see, in the limited span of 1 hour, we are trying to understand the significance of computer evidences, the hash value, which is very, very important for any kind of electronic evidence, and how audio video evidences, which are very predominantly observed in the recent days, okay, how these are examined. And before I conclude, I must also add one important factor, how the mobile phones are examined. See, the electronic evidences are examined with a very, very limited interference of the human being. See, I keep also mentioning this. The people who usually work on the digital forensics, to some extent, they are playing the role as a technician, because all they have to do is that take the evidence. If the mobile is the evidence seized, the phone, connect this to the computer, and open the tool, select 1, 2, 3, 4 options, start the examination. This particular software will start doing its own examination. It will derive all the data from the mobile phone. It prepares a beautiful report format. Everything is done automatically. All we have to do finally is that take a print of the report, sign and give it. We cannot do any kind of editing in this generated reports. That is the speciality or the uniqueness of the forensic softwares what we use for our examination. There is less human intervention. Technically, or at the examination phase, there is no human intervention at all. we are only responsible for compiling the report of different segments into one particular segment as per the case requirement. Only in this stage, the human being involvement is there, but otherwise all the back-end process, all the evidence gathering, recovery, analysis, calculating of the hash value, everything is automated. So for this reason, when you find any kind of report of electronic report in nature, first check what are the tools they have used and understand if those tools are exclusively used for forensic examinations or the examiner has used any kind of open source tools, and hence your questioning ability in the cross examination would definitely improvise. And to also understand the significance of the electronic evidence, this is what we had to discuss so far. The topic is now open for discussions and question and answers. Participants, go ahead.
Hello, sir. This is Ninad. I would like to know the recording made on the phone, can it be considered as a valid evidence?
Okay, so in electronic evidences, there are two important discussions. Discussion number one, the device in which you have recorded the data, that being evidence, that is one understanding. Second understanding is that the file is the evidence. Depending upon the case, you will question the device from which it was captured. That is one question. But depending upon the cases, you might only question the file which is the evidence. So if you are presenting a file from your side, even if you don't have the device with you, you can still plead before the court that in my case, this file is the evidence, not the device. But in some cases, the device is the evidence and addition to the file being the evidence. So any recording made on the mobile device or any of the computer device is a good piece of evidence because when you record the file, it has a date and time significance. By examination, we could confirm on which date, on which particular time zone the recording was made. We can also highlight what category of digital device was used for recording. See, suppose if it is a iPhone and you're doing a recording on the iPhone, its file properties has a different file signature because iPhone uses their proprietary software. So their compression, their frequencies in which they recorded, the file properties I'm referring to might be exclusive for the iPhone recorded devices. And if it is an Android devices will use some kind of common platforms. So like this, any recording which is made on mobile device can still be authenticated to show it as a valid evidence. This is possible.
Thank you, sir.
And you must also note a couple of important judgments. Okay, Shafi Muhammad, it is a very famous case. Shafi Muhammad's case, please make a note. Shafi Muhammad's case is important case law for the electronic records. And recently, you could also have seen the Supreme Court being mentioning that WhatsApp chat cannot be considered as an evidence. How many of you have read the judgment? Law students, did you read this judgment? You must read this because when yesterday I mentioned that one of the sources of the law is the Supreme Court judgment. It might not be mentioning in the Information Technology Act that WhatsApp data is an evidence, but the Supreme Court in different cases would have mentioned what is the approach for the electronic evidence and other things. So judgments being one of the sources of the law, it's very important as law student you follow with the sources of the laws, especially Supreme Court judgments. And one of the recent judgments, Supreme Court mentioned the WhatsApp chats cannot be considered as an evidence. Please go through the complete judgment to understand what was the background of the judge mentioning this. Suppose I have WhatsApp chat with me. I just go and show it before the court or take a screenshot of this and give it before the court. Can this be considered as an evidence? No. In this understanding, the Supreme Court has mentioned that we will not depend upon the WhatsApp chats as an evidence. But under the provisions of Section 65B of Indian Evidence Act, there is a clear-cut mention how the data from one device can be authenticated as an evidence before the court of law. In that case, they did not follow the provisions of 65B. For that reason, Supreme Court said WhatsApp chats cannot be considered as an evidence. Okay, but read the complete judgment and interpret the judgments in the actual sense. Don't be journalists, because journalists only make the news sensationalized. You are not here to make the news sensationalized, but you are here to read the complete context of the judgment. So please go through the complete judgment to understand the electronic evidence matters. Next question, please. If anybody has any question further to this. Redmi 9 power. I could not see.
Raised hand. Yes, go ahead with the question.
So myself Pankaj Kharat. So एक क्वेश्चन है मेरा, जैसे अभी आपने इलेक्ट्रॉनिक एविडेंस के बारे में बताया था, और सर राज कुंद्रा का जब केस हुआ था और शिल्पा शेट्टी का, उसमें उनके व्हाट्सएप चैट्स ओपन हुए थे जो उसके बिजनेस पार्टनर के साथ थे। और दूसरी ये बात है कि जब सुशांत सिंह राजपूत और वो रिया चक्रवर्ती का ये केस का चल रहा था, तो उस वक्त भी सर इलेक्ट्रॉनिक एविडेंस वगैरह शो हो गए थे। तो सर अगर ऐसी कोई सिचुएशन होती है, सीरियस सिचुएशन, तो उसमें इलेक्ट्रॉनिक एविडेंस को एज अ स्ट्रॉन्ग एविडेंस कंसिडर कर सकते हैं, या फिर बर्डन ऑफ प्रूफ किस पे डिपेंड होगा, एप्लीकेंट पे या रिस्पोंडेंट पे?
See, in any case, as per the law provisions, the one who brings the case, in most of the cases I am referring to, one who brings the case, he has a burden of proof. But in exceptional cases where we are discussing about the rights of the woman, rights of the children, atrocities of SC/ST, in these kind of cases, burden of proof will be on the accused to prove himself that he did not do it. But in the cases which you mentioned, these are all the regular criminal cases. It's a state case. When we say state case, it is a prosecution. The government is the person who is bringing the case before the court of law. So for this reason, the burden of proof is on the prosecution in these cases which you mentioned. But yesterday we also discussed about the importance of circumstantial evidence. Whatever the evidences are found in the mobile device must also be corroborated with the circumstances of the case. It might show some indications on the mobile device, but circumstances of the case must also be supporting the whole thing. So इसीलिए एक केस जब बनता है तब जब we have a complete timeline of the events, उसके साथ कुछ evidences, material evidence देखने के लिए कुछ मिल जाता है। See, मानने के लिए बहुत सारा होता है, देखने के लिए कुछ मिल जाता है, महसूस करने के लिए और कुछ मिल जाता है। So suppose I quickly give you an example of the Kashmir Files movie. Kashmir Files today, is there anyone who is showing the real instances which happened as a rape, real instances which happened as a barbaric nature? You don't see any evidence in that. You only see the claims. Okay, people have been saying this. There are many who would have seen this, and because of which they are telling this. That is one understanding. And if you want to prove this, where do you go and get the dead bodies or anything like that right now, which is 30 years old, isn't it? So few things have to be supported by the circumstances. As for circumstances, it goes. I'm just taking a movie example which is happening today. So it's not like I'm offending or defending any of the instances in the movie. I'm neutral in this discussion, but in this, so as for the timeline is concerned, as a fact, the government was not there. Governor was appointed. Before this, people were actually leaving that place, or they were being driven out of the place, is what we have seen in the movie. But how do you prove it? becomes a question. So हमको ये circumstances ये बता रहा है कि there could be a possibility, like the way they have shown in the movie, because the facts supports that. This is circumstances. But to see something as a material evidence, okay, that is something which questions in the given case. And third is महसूस करना. I mean, did you really feel the whole thing? Becomes another question. So like this, the burden of proof for your question is definitely on the prosecution. The case is built based on the circumstances, the timeline of the events, material facts, and logical approach of the investigation. That's also important. Police just cannot come and say because हमको ये evidence मिला है इसलिए हम उसको arrest कर रहे हैं. नहीं. There must be reason to believe that he is the one who has committed this particular crime. So for this, we definitely can understand the whole case by Dhananjay Chatterjee's case. Even though there was evidence present, which is medical evidence in nature, based on circumstances of the case, that case was held for hanging purpose. Okay, so that shows circumstances also plays a very important role in addition to whatever category of evidences you get in the case of investigation.
Yes, sir. Thank you, sir. Thank you.
Participants, you have any other question you can ask? Otherwise, we have to proceed with the conclusion of the session.
I think there are no questions right now. Okay. So, Phaneendar sir, thank you so much for accepting our invitation and delivering 3 sessions on the different topics, and those were very insightful and those were very helpful for our students to understand all the minutes of the forensic science, and which on basically the sessions were very insightful from the point of view of the practical application, and it was all about your experience. So it was very interesting as well for all of us. So thank you so much for accepting our invitation and giving all of these particular sessions. And we would like to listen you on campus as well. So as this particular COVID situation gets over, so I am also looking forward to have you on our campus physically as well. And you are always welcome on our campus, college campus. So with this, I would like to conclude with this particular workshop on the forensic science. Thank you. Thank you so much.
Thank you. When you stop the recording, I had to add a couple of things. If you can just stop the recording.